Hi, everyone. Good evening. Welcome to the CARECEN and Women for Afghan Women presentation on immigration options for Afghan nationals abroad. Thank you so much for your patience. We know that this was supposed to be a live streamed video through Facebook. Unfortunately, we encountered some technical difficulties, and so this is likely reaching your computers later than expected. So if you're watching, we thank you. And please, however you're watching this, Facebook, YouTube, Instagram, whatever account, please feel free to comment questions as you're watching, and we will, through both Women for Afghan Women social media and CARECEN social media, and we will respond to your questions as quickly as possible. So tonight's presentation will provide an overview of the primary ways to bring your relatives to the United States. We'll give you some notes on processing times, as well as U.S. immigration updates. Please note that today's presentation is not legal advice, nor is it a comprehensive overview of each immigration option. Also keep in mind that there are exceptions to every rule and every program that we'll discuss, but we're not going to get into each of those exceptions. Unfortunately, we're not able to cover every single way to bring relatives and loved ones to the United States in one evening. Instead, tonight's presentation will cover the major and more common avenues that we receive calls about for Afghan nationals outside of the United States. So specifically, we're going to cover family-based immigration, the special immigrant visa process, humanitarian parole, refugee processing, diversity visas, the effects of entering through a border to the United States, and some best practices. If you have questions about a pathway to enter the United States or a option to regularize status in the United States that we have not discussed, please drop us a comment and we will respond as soon as we are able.
Okay, thank you so much, Megan, and thank you all for joining us. So to cover our first topic, we are going to discuss family-based immigration. Most, if not all, people are familiar with family-based immigration. To briefly explain and give an overview, family-based immigration is where a U.S. citizen or a green card holder, also known as a legal permanent resident or an LPR, submits a petition to USCIS requesting that a specific relative is allowed to remain in the U.S. with a green card or to travel to the U.S. With a green card. This is often called sponsoring a relative. So to break it down, a U.S. citizen has two categories of relatives. We have the immediate relative category, and then we have a preference category relative. So as explained on this slide, you can see that an immediate relative is considered a parent of a U.S. citizen, a sibling of a U.S. citizen, a parent of a U.S. citizen, a spouse of a U.S. citizen, and an unmarried child under the age of 21 of a U.S. citizen. Okay, so in contrast to an immediate relative, a preference category relative is a married child of a U.S. citizen. So you could just follow along. A sibling or a sibling of a U.S. citizen, a green card holder, in contrast, also known as an LPR, they can petition for a spouse and unmarried children. So note the difference between the categories, right, of petitionable relatives between a U.S. citizen and a legal permanent resident. For your relatives abroad, the main difference is really the wait time. Unfortunately, preference category relatives, they have much longer wait times. There are other differences for relatives who are already in the United States, but we're not going to go into that in tonight's presentation. Also notice who's not on the list, right? So we don't see grandparents, we don't see cousins, aunts, parents-in-laws, or other extended family members. However, if allowed to immigrate to the United States, the people on the above list except for immediate relatives, are permitted to bring their own spouses and children with them. So these are your derivative beneficiaries. And it is true that once someone has a green card, they can petition for anybody on this list. Thank you. Okay, so explained on the last slide, the main difference, right, between an immediate relative and a preference category relative is the wait time. So how long must these relatives wait? Well, the good news is that immediate relatives, they can get green cards without worrying about the visa availability waiting periods or the numerical limits. However, keep in mind there will be a wait of typically pre-COVID and pre-Kabul embassy closure, you were looking at anywhere from 9 months to a year. But now it's really difficult to predict how long it will take for complete visa processing in light of these disruptions and changes. But yeah, preference relatives, they typically have to wait years before being allowed to apply for their visa or green card because of annual limits on how many green cards, aka immigrant visas, are given out. The unpredictability of how many people will submit petitions each year, no one can say exactly how long it'll take, which is frustrating. So it's always I like to mentally prepare my clients and tell them that patience is a virtue, and that really it's always a waiting game. But yeah, all we know for sure is how long the people at the front of the line right now have been waiting. The wait times on this slide are subject to change month to month, so it's constantly being updated. Again, it's impossible for an immigration lawyer or anybody really, unless they have a crystal ball, to be able to tell you how long it'll take. Yeah, so it's unfortunately, there is no way to speed up that process. We just have to be patient. Now, next slide. So we actually, this is a sample of an I-130 approval notice for a sibling of a US citizen. You'll see circled in red the priority date. Okay, so we are going to cross-reference this date with the next slide. So we're basically going to take that priority date and the approval notice, and we are going to go to the Department of State's visa bulletin, which is posted on their website online, and we're going to look at the category for our relative. Again, these dates are updated each month, so you can find a visa bulletin for January 2023, one for February 2023, one for March 2023. And they sometimes they do post ahead. So yeah, as a general rule, applicants in the higher preference categories wait less time. So just to give you an example, using the previous sample approval notice, right, from the prior slide, that was, as I mentioned, a sibling of a US citizen with an October 2010 approval date, priority date. So because a sibling of a US citizen is placed in the F4 category, we're basically going to go down to the F4, row F4, okay? So because brothers and sisters of US citizens are their fourth preference category. So let's assume this person was from Afghanistan. So because this is an Afghan national that we're talking about, we're going to look at the all chargeability areas except those listed, which basically means all the countries except those that are listed, for example, China, India, Mexico, Philippines, right? So if we go down, we'll see that March, the date in that box reads March 22nd, 2007. What does that mean? That means that the National Visa Center and the Department of State, they're only scheduling interviews for people with priority dates on or before March 22nd, 2007. So just judging based off of that, the petitioner can, they can gauge how much longer it'll take for the visa to become available. Okay, next slide. So now let's put this into practice. So you have a qualifying relative and you warn them that this is a long process, but they still want to go forward. They still want to move forward and go through with it. So what's next? So the petitioner, who's either a US citizen or a LPR relative, who's based in the US, they're going to submit an I-130 petition to the United States Citizenship and Immigration Services. And step two is essentially waiting, right? Like I've mentioned, this is all a waiting game. So we have to wait for the priority date to become current. Once the priority date becomes current, the National Visa Center will contact the petitioner regarding next steps, which at time the petitioner will have to submit additional civil documents, Form DS-260 that contains biographical information for the beneficiary, and also the affidavit of financial support and supporting documentation. And once the case is documentarily complete and qualified, as per the National Visa Center, once they're satisfied with all the documents that were submitted and they were accepted, the visa applicant, aka the beneficiary, right, a relative that we're applying for, they're then placed in queue for their visa interview. So just a note on the interview, you're not just waiting on the priority date, we're also at the mercy of the embassy, and their availability, the embassy or the consulate for their availability. So, and keep in mind that a lot of times, your relative might have to travel to this embassy or consulate for their visa interview, which maybe a city a couple hours away. Now, next slide. Thank you. Alrighty. And now, important question. What are the filing/processing fees? So the standard I-130 application fee is $535. And in connection with that I-130 petition, you also have the visa processing fees, which amount to $445 currently. And that's the sum of the two items that are here on the slide. So you have the State Department's application processing fee, and then you also have the financial support form fee. But recently, USCIS, they announced a fee exemption for fee exemptions for I-130 submitted on behalf of Afghan national relatives, and that's effective through September 30th, 2023. However, the fee exemption, it's not retrievable online, unfortunately. You wouldn't be able to process an I-130 through the online USCIS online account without having to pay for it. So the way that you would request the fee exemption is by filing a paper I-130 form. Okay. Now,
normally we would
have
individuals asking questions. However, if you have any questions that come up, please post these on social media. And as I said, we will get to them as quickly as we can.
Yes, and please reach out with any questions. We're more than happy to answer them for you.
Thank you so much, Susan, and thank you, Megan. So next we want to go over a program created that was named Special Immigrant Visas, also known by many as CIV. And so this is a protection created by the U.S. government for those for people who assisted the U.S. military forces or allies in Afghanistan. There are currently two programs in place at the moment. One is specifically for translators and interpreters who assisted the military, and the other is for people who did general work for the U.S. government and military. A person can qualify for one or both programs. So first I'm going to go over the requirements for individuals who were employed on or behalf of the US government. So in order to qualify for that program, you must submit a number of things. So first, you should have been employed have been employed in Afghanistan by or on behalf of the US government or by the International Security Assistance Force successor mission for a period of at least 1 year between the dates of October 7th, 2001 and December 31st, 2004. Currently, this program you can apply up until December 31st, 2024. Next slide. And so for to do this application, you have to submit a number of documents. What you have to do is submit the documents listed on the slide. And once you've gathered all the documents on the slide that are stated, you have to submit them to the email listed on the slide. Once you submit everything, you will receive confirmation from that email that it has been received. The email that that is submitted must contain the principal applicant's name as it is written in the passport or Afghan national ID known as a tazkira, and plus the applicant's date of birth using the format of day, month, and year. And if you submit any documents that are not in English, please remember that those documents must be translated and certified. So this specific program on the slide is for individuals who worked with the U.S. Armed Forces or under Chief of Mission Authority as a translator or interpreter. So if you meet the requirements below, you were an Afghan national and you work directly with the armed forces as a translator or interpreter, and you have a letter of recommendation from someone in the U.S. Armed Forces that attests to your work, you can qualify for this program. Next. So unlike the previous process where if you worked on or behalf of the U.S. government, this petition must be first submitted with USCIS. And once that application is submitted, then it is sent or referred to the National Visa Center for next steps. It's kind of similar to a family petition where you are sent to the National Visa Center and you have to wait for an interview and wait through that process. And next slide.
So again, please make sure to post any questions and we'll be monitoring. So next we'll be speaking about refugee processing. And Kenya, I believe you're going to speak about this, right?
Sure, definitely, Megan. Thank you so much. Thank you, Susan, and thank you, Stephen. Many of you have probably heard of asylum and may know someone applying for asylum right now. The difference between refugees and asylees is where the individual lives during the application process. Asylum seekers apply for asylum from inside the United States. Refugees apply for refugee status through the U.S. Refugee Admission Program and other international and non-governmental organizations such as UNHCR. Importantly, you can include spouses and unmarried children under 21 in refugee processing. This means that those relatives can be included in the applicant's process and enter the United States as refugees together. We'll speak in a bit about what happens when relatives are not included in the initial process. The United States admits a set number of refugees each year. The number is determined by the president in consultation with Congress. For the fiscal year 2023, the United States can admit 125 refugees. Remember, though, that that number is in total admissions globally, not per country. Refugee processing is a very long process. It might be years before someone is admitted to the United States or another country as a refugee.
And I'll just quickly note that that's 125,000 refugees per year.
Yes. There are three categories of refugees processing. The first two categories are fully under the control of external agencies, organizations such as UNHCR, embassies, or the US Refugee Admissions Program. Basically, an immigration lawyer cannot apply from the United States for someone in categories 1 and 2. So we're going to focus on group 3. So let's talk about the third category on the prior slide. Suppose you have been admitted to the United States as a refugee, or you have been granted asylum. How do you bring your relatives to the United States? First, refugees and asylees have 2 years to apply for qualifying derivative relatives using Form I-730. Note that the refugees must apply within the first 2 years of their admission to the United States as refugees. Asylees must apply within 2 years of being granted asylum. However, both refugees and asylees can apply to waive the 2-year filing requirement for humanitarian reasons. Both refugees and asylees can request derivative status for spouses and unmarried children who were under 21. 2 important notes. First, the marriage must have occurred at the time of the refugee asylum decision. Second, your unmarried child must have been under 21 when you applied for asylum or interviewed for refugee status. That is to say, it is okay if your child is under 21 at the time of the derivative application. However, the child must still be unmarried. So what about other relatives? Other relatives who fear harm of the same situation or reason, that you received refugee or asylum status may be able to join you in the United States. The Refugee Resettlement Agency can help you submit an affidavit of relationship to start refugee processing for that relative. Importantly, only a designated refugee resettlement agency can assist with the process. Catholic Charities and International Rescue Committee are 2 refugee resettlement agencies in the New York State.
Great, and as always, post some questions. I also realized that in my eagerness, I skipped past humanitarian parole. So I'm going to go back a couple of slides and make sure that we cover humanitarian parole. So humanitarian parole, at its best, is meant to act as an option for emergency situations. USCIS has the discretion to grant humanitarian parole for someone facing urgent circumstances who otherwise would not be allowed to enter into the United States. And discretion refers to USCIS or US Citizenship and Immigration Services ability to grant or deny at will based on the information provided. In considering humanitarian reasons, USCIS looks at the immediacy of the circumstances, the effect on the person's welfare and well-being, and the degree of suffering if parole were denied. In contrast, significant public benefit reasons, which is the other way you can receive humanitarian parole, generally refers to law enforcement and national security reasons to bring someone into the United States. So unlike family-based immigration that Susan described at the beginning of this presentation, humanitarian parole has no relationship requirements. You can apply for yourself or you can apply for someone else, regardless of whether or not they are related to you. And there is also no limit to how many people you can apply for. If granted, humanitarian parole allows an individual to enter the United States for a specified period of time, generally around 1 year. While in the United States, that person can then apply for other forms of immigration relief not available to them outside of the United States. For example, temporary protected status or asylum. So I just described humanitarian parole at its best. Unfortunately, humanitarian parole for Afghan nationals is not being processed at its best. According to a recent report by the American Immigration Council, USCIS received over 44,000 applications for humanitarian parole, specifically from Afghan nationals, between January of 2020 and April of 2022. Of those almost 45,000 applications, only 114, or 0.3%, were granted. Over 2,000 applications were denied, and 42,000 were still pending at the time of the report. So what does this mean for your friends and relatives abroad? Humanitarian parole is still an option. And actually recently we are hearing about some people, receiving updates on their cases. And for many people, it might be the only option. However, it's a long process. Tens of thousands of humanitarian parole applications for Afghan nationals have been pending since 2020 and 2021 without response. This doesn't mean that they will necessarily be denied, but it is taking years. We are also seeing that USCIS seems to require even more evidence for humanitarian parole from Afghan nationals. So we recommend being as detailed as possible in applications. Many attorneys are preparing these like asylum applications. Describe in detail the specific reasons that family members or friends are in danger. Remember that there are thousands of these pending, and USCIS receives more each day. You want to make sure that your application is prepared in a way that USCIS is going to notice it, and that they'll, out of the 45,000 plus that are pending, that they'll try and look at that one and give it attention. So as always, comment your questions.
Thank you, Megan. So next we're going to talk about the diversity visa lottery. It's a form. It's like the name says, it's diversity. It's a lottery. And so the diversity visa lottery was created to increase immigration from countries that historically do not immigrate to the United States. The government allocates approximately 50,000 visas each year, and those 50,000 visas are allocated to different regions and countries by the Department of State using a formula that they have created. Afghan citizens are eligible to register for a diversity visa if they have the qualifying education or work experience. In 2018, the most recent year that we have data for, 636 Afghan citizens received diversity visas. It's important to know that you can also register for the lottery if you are in the United States with temporary protected status, which is known as TPS or asylum, parole, etc., as long as you meet the requirements that are noted on the slide. You can find diversity visa application as well as helpful instructions on the Department of State's website. Registration typically occurs between October and November. The applications is open within those months, and it closes, and we advise to apply as early as possible. Selection typically takes place around May of the following year, and during selection, the Department of State randomly chooses applicants based on the number of open slots per region and country. If you're fortunate enough to win a diversity visa, the next step would be to fill out Form DS-260 to request a consular processing interview at the appropriate embassy or consulate, and which you will be then subject to availability of the consulate or embassy for interviews.
So far, we've spoken about family-based immigration, about special immigrant visas, refugee processing, humanitarian parole, and diversity visas. With the exception of refugee processing, which, as Nya indicated, is kind of its own separate process. All of these are applications requiring an initial, all of these are pathways to status that require an initial application with USCIS or the Department of State, and then consular processing. And consular processing is when someone has an interview at a US embassy or consulate to talk about the individual's immigration application. The Department of State, through the embassy or consulate, then issues or denies the application. For these forms of relief, individuals applying for a green card, or in the case of humanitarian parole, permission to temporarily enter the United States before booking travel and entering the United States. However, as we've repeatedly discussed during this presentation, these applications often take years. And for so many reasons, not everyone can wait years in Afghanistan or in another country before coming to the United States. So many people leave Afghanistan without a visa or other permission to enter the United States. And they travel to the United States trying to enter the border at Mexico or the border with Canada. Many people are intending to apply for asylum once they reach the United States. It's important to know, however, that at both borders, entry is subject to Customs and Border Enforcement discretion. This means that the Customs and Border officials who work at the northern and southern border have a lot of power over whether somebody can enter the United States. If a friend or loved one is fleeing Afghanistan and afraid to return, then that person should say that to an officer at the border. However, it's important to note that the United States has had various agreements and policies over the past few years with the explicit goal of limiting who is allowed in the United States to seek asylum. This is a constantly evolving situation that honestly could be its own presentation. So I'm just going to quickly touch on, 3 specific programs and agreements that you might have heard about in the news recently as examples of the barriers to entry at a border. However, please note that these are, again, these are subject to continuous litigation and are constantly changing. And so, this might not be the situation by the time somebody is arriving at the border. So to start with the Canada-US Safe Third Country Agreement. The United States and Canada recently announced that they're going to expand their Safe Third Country Agreement, which limits the ability of individuals to arrive in one country and then seek asylum in the other. Basically, the idea is that if somebody first arrives in Canada, that person is supposed to seek asylum in Canada and not travel through Canada to seek asylum in the United States. Again, this is an agreement that is the subject of pending litigation, and it remains to be seen what will happen to it in the future. But as of the date of this presentation, April 28th, 2023, this is currently in effect. Similarly, Title 42 is a program within the United States that grants administrations authority to limit entry to the United States based on public health justifications. So since March of 2020, Title 42 has been used to keep people from crossing the border based on COVID rationale. It's set to expire on May 11th. And finally, I'm just going to mention the Migrant Protection Protocols, which is known colloquially as the Wait in Mexico program. This is the program that required people applying for asylum at the border to remain in Mexico during the asylum case. This truly created a humanitarian crisis. Thankfully, this program is no longer being implemented, but I mention it because both administrations have defended this program's legality, which does leave open for similar policies in the future. So, we just spoke about some policies that affect an individual's ability to enter the United States from Canada or Mexico. And now we're going to talk a little bit about the consequences of seeking asylum and entering at the border if you make it into the United States. So if someone makes it into the United States from the border, that entry without permission into the document really has significant and large consequences on an immigration case and options in the United States. Many of those consequences stem from the fact that even though a border official might be seemingly allowing you to enter the United States, that person does not actually have status or the ability to stay permanently. So if someone is able to enter the United States at a border, or if somebody enters the United States at a border, whether by processing and asking for asylum or entering without permission and then later being caught by border officials, that person will be entered into removal proceedings. Removal proceedings take place in immigration court. In essence, a government attorney is trying to deport that person. And then that individual has to present a defense against immigration, which is, a reason that they should be allowed to stay, a pathway to status. One example is when people apply for asylum in immigration court. We highly, highly recommend that anyone with a removal case, anyone with a case with an immigration court, contact an immigration lawyer. So the second consequence of entry at a border has to do with family-based immigration. Earlier, Susan spoke about family-based immigration and all of the relatives that you could petition. Entry at a border may affect an individual's ability to apply for lawful permanent residence based on their relationship to a lawful permanent resident or a U.S. citizen. Once again, this is a very complicated area of immigration law that requires waivers and a full consultation. So we recommend contacting a lawyer. If you are in the United States in removal proceedings, entered without, entered at the border and are hoping to apply for status based on your relationship to a U.S. citizen or lawful permanent resident. So the next consequence of entry at the border is more practical, just affecting daily life. Individuals who enter at the border who are in removal proceedings may need to check in with Immigration and Customs Enforcement, also known as ICE, on a weekly, bi-weekly, or monthly basis. These check-ins can be inconvenient, but are important. Individuals in removal proceedings also need to update ICE, the court, and/or USCIS with all address changes. So these are not all of the consequences of entry at a border without permission, of entry at a border seeking asylum. However, there are some big ones. And the main point is that anyone thinking, about how they're trying to get to the United States should just know that the immigration process is going to look different than if, for example, applying for having a relative petition for you, and going through consular processing. So next, we have some best practices. If you are, intending to help others apply, or if you are talking with your relatives or friends abroad about their options and how they might be able to come to the United States. First, as should be evident from this presentation, immigration law is very complicated and the details matter. Again, I think this is my third time saying it and it bears repeating. It's worth repeating. We highly recommend at least consulting with an immigration lawyer before submitting any application. However, we will note that not all immigration lawyers are equal. Many lawyers try to prey on non-citizens' lack of knowledge about the process. So do be aware of any lawyer who promises outcomes. Immigration law is incredibly complex and it's hard to win these cases. No lawyer should be telling you that it's an easy process or that status is guaranteed. Similarly, immigration lawyers should be giving you a retainer agreement that outlines exactly what the lawyer has been hired to do. And finally, if you're paying a lawyer, then that lawyer should always give you a receipt, and you should know at the start what the costs of representation are. So let's say you consult with a good lawyer and you you or they prepare an application, always make sure to review that application with your relative or friend abroad. Don't guess at information. Make sure to review it, talk through WhatsApp, video chat, however you can, to just double check and make sure that birth dates, spellings, all of those details are correct. Because even something like, one number being missing in a birth date or the spelling of a name can really make a difference and can cause USCIS or the Department of State to ask more questions. Third, keep a copy of all documents and forms that are submitted to immigration. The Department of State and USCIS will often compare all of the applications submitted for an individual to see if the information is consistent. And if that information is not consistent, then they're going to ask about that. So it's very helpful to have a copy of all of the applications so that, a lawyer or down the road, you can just make sure that everything's the same and, know in advance if USCIS is going to have some questions. Fourth, relating to family-based immigration and special immigrant visas and humanitarian parole, all of those application processes. Think about consular processing in advance. If you have a relative who is currently living in Afghanistan, the embassy in Kabul is shut down. And so try to come up with a plan with that relative. How can they safely leave? And what country can they travel to for an interview? We know that it is very difficult to get these interviews. And if someone misses an interview, it can be difficult to reschedule. Next, set expectations with your relatives and friends. This is a long and difficult process. There are few, if any, ways to speed it up. So you want to make sure that your friends and relatives understand the process that they are starting so that they can plan accordingly for how long it might take. And fifth, and finally, or rather sixth, and finally, advocacy. Legal change is difficult in the United States, but it is possible. US citizens watching this, vote in federal, state, and local elections, call your senators and representatives, tell individuals that tell your representatives the changes that you want to see.
Thank you again, Megan. Excuse me. How can we help you? Women for Afghan Women's Services. The services that we have here at WAW are case management, legal immigration services, English classes, citizenship classes, adult empowerment classes, women's circles, financial literacy workshops, and senior programs. So let us help you. Please contact us at womenforafghanwomen.org.
And similarly, at CARECEN, which is the Central American Refugee Center, although our name says Central America in it, we represent all individuals regardless of national origin. So within our legal program, we have a citizenship program, a low bono program that provides affirmative matters, including family petitions at lower cost. We have an ONA legal counsel program that provides consultations across Nassau and Suffolk County, a removal defense program, as well as our Afghan legal project housed within our special projects program. So, please reach out if you need legal assistance. And we also, outside of the legal program, have a number of community programs, including citizenship classes, English classes, social work services. We have a new job training program, and many community events, including accessing medical care, about professional skill building, financial literacy, and more. So our contact information is on the last slide, but check out carecenny.org for more information and please reach out if you're interested in any of these services. So that concludes our presentation on immigration options for Afghan nationals abroad. Again, if you're watching this, thank you for bearing with us through the technical problems watching this at a later date. CARECEN's and Women for Afghan Women's contact information and addresses are listed on this slide. Please do not hesitate to reach out with any questions and follow us on social media. Thank you.